Hi folks, and welcome back to Conveyancing. This is video 2 in the video series on formation of contract. And you will recall that in the first video we had a little look at the various different requirements that Section 59 of the Property Law Act imposes in order to provide some safeguards against fraud. So you can't take an action on a contract for the sale or disposition of interests in land unless the contract or a memo or note of the contract is in writing and signed. So we had a little look at all the various different components there that are highlighted in yellow, and now we need to work out, well, okay, what's the story for our client if in fact some of those or all of those conditions have not been met. And so now let's go forward and have a look. Well, the upshot of things is that the contract itself will be unenforceable. Now, think back to your contract law days when we laboured ad nauseum the difference between a void contract, a voidable contract, and an unenforceable contract. Unenforceable contracts are not void, okay? And there is a big difference between the two and significant consequences. Okay, so because the contract is not void, simply unenforceable, that is, you cannot sue upon the contract. You can't take the other party to court to get what you need from them. The contract can still be used, though, in a number of very important ways. Probably the most important way is the second bullet point there. The contract will still be sufficient to pass title in the property. Okay, so the title will pass. It's just that you can't sue on the contract. It can also still be used if one of the party tries to take you to court and obtain an order for specific performance. Obviously, then you can use the fact that the contract is unenforceable because of its non-compliance with Section 59 of the PLA as a defence to that suit for specific performance. If the deposit money has changed hands, all important question of the deposit money, what happens to that then? Well, it will really depend on who has defaulted and as to how they can go about getting the money back. If the buyer has defaulted, if the seller can get the deposit, if for example, if the seller's already received the deposit and they don't have to take the buyer to court to get the deposit monies paid over to them, then they can certainly just keep that deposit. If the seller defaults, then the buyer can take an action in restitution in what used to be called an indebitatus assumpsit, actually, for money had and received. Very old-fashioned, old form of action, not reliant on contract at all, and basically you're saying the other party is in debt to you for money that they've had and received. They're not entitled to keep that money that they have had and received. So that is the means of redress there. Exceptions, well, the first one is the doctrine of severance. So if you find that you're in the happy situation where all the essential terms of your contract actually are in writing, but there are other terms that were made by parole, so orally, then if those oral terms can be severed successfully, leaving a complete contract that was written that can stand on its own, then you can seek severance, seek an order for severance, and you can then, obviously, the surviving part of the contract that's left will satisfy the PLA, so you've got around the problem that way. The other one is fraud. So obviously, if the whole reason why you can't satisfy the requirements of Section 59 of the PLA is because something the other party has done to prevent this, then obviously equity is not going to let the PLA be used as an engine of fraud, and you won't be able to set up an argument of non-compliance with the PLA there. The other doctrine that grew out of this concern to prevent the PLA from being an engine of fraud is where one party has fully performed all of the agreement and the other party just kind of sits back and says, that's really good, thanks, give me all of your performance. And then the other party's finished performing and says, how about it, let's finalise this deal, you perform your part of the transaction. And you say, oh no, sorry, yeah, that's section 59 of the PLA. You can't do that, obviously. Either where the other party has fully performed, or that then grew into, well, as the doctrine of partial performance, part performance, where you have done sufficient acts of part performance, then once you get to that critical mass of part performance, then you won't be able to set up section 59 of the PLA as a reason for escaping that contract. And that segues nicely into the doctrine of part performance. McBride and Sandland is the case there that set out the requirements for setting up an argument of part performance. Obviously, the performance, the act that you're relying on, or acts of performance, must unequivocally and in their own nature refer to an agreement as alleged. Secondly, the act must be done by the party relying on the acts in faith of the agreement, and the other party, here's the key, the other party permitted them to do so on that footing. Okay, that's where you've got the inequitable conduct. One party's thinking, I've got one foot out the door, I don't have a contract here, there's no fulfillment of the legislative requirements of writing and so forth. But you know what, I'm just going to let the other party do what they think they're contractually obliged to do. I'm just going to sit back and take it all. Then basically 3 and 4 are just the actual, practical requirements. The party seeking to enforce the contract must have actually done the acts, and the agreement must have been concluded. Not real rocket science here, just I guess a really good example of the growth of an equitable doctrine that has been necessary given the very harsh consequences of a contract being found to be unenforceable by virtue of the Property Law Act. And I guess the checks and balances that need to be made to avoid the unfair consequences sometimes, but to a party that has unwittingly failed to satisfy the statute of frauds requirements in the PLA. So variation, waiver and discharge, you will recall from your contract days. A contract is very much a living thing, and you may tinker around with the terms, that's a variation. You may tinker around with the mode of performance, or you may decide to put the old boy out of its misery and discharge the contract. So contracts for the sale of land, how does all of these concepts bear upon land contracts and the requirements under the PLA? Well, firstly, for variations, you've got to remember, as I say in that first bullet point there's no bright line to distinguish a waiver or a variation or a discharge. And these terms, what one judge might find to be a waiver, another may find to be a variation. So this area is a bit of a mucky area at law. But in terms of variations, I think it's easiest to conceptualize them as being a change in the actual terms of the contract. And because a variation tinkers around with the terms of the contract, then where it's a land sale contract and section 59 bites, you're going to have to make sure that any variations are also in writing. Obviously there needs to be consideration because you've got terms being changed, so it has to have all of the formalities that you do with any contract formation. So you need to have these things in writing. In terms of discharge, there's actually a mixed set of opinions on discharge and whether discharges of land sale contracts need to be in writing. The authors of the text seem to suggest that, under Section 59, because a discharge of a contract doesn't technically meet the strict terms of 59. I mean, 59 applies to contracts for the sale of land or other disposition. So because a discharge is not a contract for the sale of land, they suggest that possibly you don't need to get a discharge in writing to satisfy the PLA. There is other authority that does suggest that, given the definition of disposition that we saw earlier on in this video, and the fact that dispositions also cover releases, then I think the authors very prudently suggest that your best bet is to make sure that any discharges are obtained in writing. Waivers can be very, very close to variations, and there, as I said, there's no bright line here. And it will often just come down to, the facts of the case and almost what the judge had for breakfast. Again, the easiest way to conceptualize it, I think, is a waiver as being tinkering around with the mode of performance rather than the terms themselves. And because that's the case, then you're not going to have to worry about getting those kinds of things in writing so far as the Property Law Act is concerned. So extensions of time and that kind of thing, the PLA won't really bite on those. However, I mean, it's obvious, isn't it? If you're acting for the party that is going to be seeking an extension of time, just for mere prudence sake and best practice, you would obviously want to have that in writing wherever possible. Okay, so, but as far as the PLA is concerned, it's not going to cause a problem there. Doesn't require consideration, again, because you're not actually tinkering around with the terms. You're tinkering around with the mode of performance. So in the agricultural and rural finance case, you can collectively see the High Court basically just throwing their hands up and saying there's no conceptual, adequate conceptual distinction here between a lot of the terms that get bandied about. They basically saw waiver as this umbrella term that underneath this umbrella term hung off a lot of different labels that tend to get used, election, estoppel, variation, and there's often very little between particularly variation and waiver, and they're the kinds of label that get used in circumstances where one party unilaterally waives or discharges terms in a contract. And so the situation is a bit muddy. In the tropical traders case, at least, they did hold that an extension of time, which authorities I think would indicate may be a waiver. At least we know it's not an election. It's more of a postponement of strict enforcement of your contractual rights. So it's not going to constitute an election there. If that has been granted, an extension has been granted, then obviously you're going to be looking at something like estoppel to try and enforce that extension of time that has been given. So bit of a muddy area, and again, nice segue then into the final issue that we need to cover off, and that is estoppel. So you'll all be intimately familiar with the doctrine of estoppel. We went through that in contract law, good old Waltons and Marr, who can forget that. Poor old Mr. Marr demolished the building on the faith of the evil Waltons empire, representing that they would enter into this contract for lease with Mr. Marr. He goes ahead and demolishes the building, and then Walton Stores end up trying to back out of that agreement. The 6 elements were set out in that case. It might pay you to revise them if you haven't already for this unit. But where does that interface with the Property Law Act? Well, estoppel as a doctrine is designed to get around the fact that there is no contract, but the PLA actually is designed to reduce the opportunity for fraud by requiring a contract. And if you let estoppel have too much of a free hand in this area, then obviously you're going to be undermining the intent of the legislation to reduce the scope of opportunity for fraud. So just alleging there is or would be a contract is probably going to be insufficient here in order to get a successful argument of estoppel across the line for the purposes of the Property Law Act. It's probably only going to be available where there's sufficient acts of part performance, like poor old Mr. Ma. And to found a successful estoppel argument, you're going to have to show that there was an unambiguous representation, either, well, that there was a contract, and either explicit assurance that the statute wouldn't be pleaded, which is going to be very, very rare, or there's something in the conduct that suggests the other party would actually still honour the agreement even though there had been no writing. And that's where your inequity steps in, your inequitable conduct. That's what founds your estoppel. So Walton's probably being the paradigmatic case there. There are other devices that courts have used in order to try and get around the fact that there is no written contract for the purposes of the statute of frauds type legislation, such as the PLA. Sometimes courts have imposed constructive trusts. There's been mixed reception here that takes notes that the courts have been loath to introduce this into the law as between the seller and buyer, but there is a bit of movement in this area and courts seem a little bit more receptive to the use of constructive trust than perhaps previously. I'm not going to place too much emphasis on constructive trusts in this unit. It's probably just a good little, bookmark to file away in the back of your mind there. It's just another example of the way that courts can try and get around this kind of legislation if they are of a mind to do so. So that is the first of our video series in formation of contract, and next week we will have the concluding 2 videos, maybe more. Next week we'll have the concluding videos for part 2 of formation of contract. That's about all we need to say for today, folks. As I always say, if you have any queries or questions, please don't hesitate to contact me. Drop me a note on Teams, however you'd like to do so. I look forward to seeing you in a tutorial sometime soon, hopefully. Other than that, bye for now, guys.